Welcome to the Idaho Supreme Court. This is the case of Pizzuto versus Idaho Department of Correction. Appearing on behalf of Gerald Ross Pizzuto Jr. is Mr. Jonah Horowitz. Good morning, Mr. Horowitz.
Good morning, Your Honor.
Can you adequately see the timer for this hearing today?
I can, Your Honor. Thank you.
Thank you. And we have for the State of Idaho Department of Correction, Ken Jorgensen. Good morning, sir.
Good morning.
You will note that Justice Colleen Zahn has been or has recused herself, frankly, from this case. And we have Justice Roger Burdick appearing in her place. He will participate fully in this case. Counsel, do either of you have any preliminary matters for the court prior to your argument?
Nothing from Mr. Pizzuto, Your Honor.
No, Your Honor.
Well, Mr. Horowitz, please.
Thank you, Chief Justice, and may it please the court. The question presented in this case is whether the public will have any input into the process by which inmates in Idaho are executed.
Excuse me, I cannot hear you, Mr. Horowitz.
Oh, I'm sorry, Your Honor.
Can everyone else?
Yes.
Yes.
Okay.
Can we also verify IPTV is streaming? I'm not seeing anything yet.
Could we have IT help with this, Madam Clerk?
Yes, just one moment, please.
Idaho Public Television may go off.
All of a sudden, I can't hear
momentarily.
you, Madam Clerk, either. Chief Justice Bevan, would you say something?
Can you hear me, Justice
I
Burdick?
can't hear you either. I'm sorry, sir.
Justice, I will jump on and take a look. Justice Burdick, can you hear us now?
Yes, I can, and thank you, Brandy.
Can you hear me,
Excuse me,
Chief?
folks.
Former
Sorry.
Chief? Justice Burdick, can you hear me?
Yes, unfortunately, sir.
Mr. Horowitz, will you say something just to make sure we're all okay?
Can you hear me, Justice Burdick?
Yes, thank you.
Right.
And
And then
Again,
Idaho
please
Public
excuse me.
Television may begin streaming again if you have ceased doing so. And with that, Mr. Horowitz, please.
Thank you, Your Honor, and may it please the court. The question presented in this case is whether the public will have any input into how executions are carried out in Idaho, which is the most important power that's exercised by the government. I'd like to start, if I may, with the APA claim that we've asserted, and to address three questions pertaining to that claim. First, whether the director of the department has rulemaking authority. Second, whether the director is exempt from the APA. And third, whether the protocol is a rule. Turning to the first of those questions, whether the director has rulemaking authority, I believe the plain language of the relevant statutes controls that question and answers it in the affirmative here. The APA itself defines a rule as an agency statement prescribing procedure. And in 19-2716, that's exactly what the legislature told the director to do with respect to the execution protocol. It directed him to issue a procedure for all executions. There were a couple of dictionary definitions cited in the briefs. I did want to call the court's attention to one more, also from Merriam-Webster's, and that is that one of the definitions of the term rule is in fact procedure, which just reinforces the overlap between the statutes here and refutes the state's position that there is some discrepancy between those two terms. I also wanted to say a brief word about the legislative history. I would suggest the legislative history does not need to be consulted because the plain language here is definitive. But if the legislative history is considered, it supports Mr. Pizzuto's interpretation of the statutes.
Before we go any further with that sentence that you've been talking about, the director of the Idaho Department of Correction shall determine the procedures. I know you've been focusing very much on procedure. I'd like to focus on the language shall determine. Does that have any effect on our analysis here? It doesn't say shall promulgate or shall propose for review. It says shall determine. Does that language change the analysis?
I don't think so, Your Honor. I think determine is essentially in this context synonymous with those other terms such as issue or promulgate, the sorts of verbs that have been suggested by the state as perhaps more traditionally used in rulemaking, grants of authority, and statutes. But here, I would say the word determine means no more than the director. There needs to be some verb there, and I would say determine serves that same purpose. It's essentially just indicating that the director is the one who is issuing the protocol. He is the one who's deciding what goes in the procedure, which in substance, in my view, is the same as issuing or promulgating the procedure.
Well, the legislature picked that word. They could have picked promulgate or propose, but they picked determine. Does that word not suggest some finality?
I suppose I would say, Your Honor, that it doesn't imply any finality than a word like issue or promulgate. To me, it would be different if the verb. The state's theory is that the statute 2716 gives to the director a sort of case-by-case responsibility for figuring out how executions will be carried out. And if the word determine appeared in a different sentence, I would certainly grant that it could change the calculus. For example, if it said something like the director shall determine on a case-by-case basis would obviously be the most straightforward wording, but then the word determine would absolutely be consistent with the state's understanding of the statute. But in the absence of any other terminology along those lines, I would say there's nothing about the word determine in this sentence that's in 2716 that would suggest that there's not a rulemaking authority granted. It's a word that is associated with case-by-case adjudications. So if the director were told to determine, it could be used in a case-by-case type of statute, but that's not the statute we have now. Moving to the legislative history, the district court's conclusion was that 2716 does no more than tell the director to effectively make sure that the execution happens. And it's true that that's what the statutes used to say, but the difference between the current statutes and the prior statutes is very significant here because the prior statutes did not include that word procedure. They did include verbs much more like what the district court had in mind, the word do, for example, do the execution. But the legislature specifically chose to enact the word procedures in the statute, and that is the word that brings the statute and the protocol within the ambit of the APA. And that change in the statutory language has to have some significance. It can't be that the legislature had no reason for making that change. And as for the director's supposed exemption from the APA, the statute that is relevant here exempts the Board of Correction. It does not exempt the Director of Correction, and it does not exempt the Department of Correction. And again, that legislative choice should be respected. And it is not the board that issues the protocol. It is the director, and he does so in his capacity as director of the Department of Correction. And it's true, as the state has emphasized, that the director has a status with the Board of Correction, but he doesn't issue the protocol pursuant to that status, which we can tell by looking at the protocol for one thing. And for another, the statute, again, is specifically addressed to the director of the Department of Correction, not to the board. This court's Carmen decision is also harmonious with Mr. Pizzuto's reading of the exemption from the APA, because the upshot of Carmen is that when there's a part of the correctional entity or the correctional agency in Idaho that invokes the board's exemption from the APA, that exemption only applies if the entity is acting pursuant to its authority that's delegated by the board. And here, the power to issue the execution protocol was not delegated by the board, it was delegated directly by the legislature in 2716. And the final area I wanted to touch upon for purposes of the APA claim are the 6 factors under ASARCO that guide this court's analysis into whether the protocol does constitute a rule within the meaning of the APA. The first of those factors is whether this agency statement has wide coverage. And here it applies to an entire class of individuals, namely all of the inmates on death row, and it applies to an entire type of activity, namely all executions. It also has general and uniform application, which is the second factor, because its evident purpose was to make all executions uniform and consistent. It applies only to future cases, which the state does not contest. It includes directives that are not in any statutes. The statutes on this subject are quite general. There is 2716 itself, which does little more than select lethal injection as the method in Idaho. And there's another statute that provides some parameters as to who can visit the inmate as his execution nears. And the protocol does everything else. It includes a very detailed and comprehensive list of tasks and responsibilities and duties associated with the execution. The penultimate factor is whether the statement is a new agency policy, a policy that has not previously been expressed by the agency. And here we identified 3 directives in the protocol that were not in the prior iteration of the protocol, which the state, again, has not controverted. And finally, the protocol interprets law or policy in a host of different ways. It interprets 2716, it interprets the statute about who can visit the inmate, and it interprets a number of constitutional precedents regarding the 8th Amendment right to be free from cruel and unusual punishment at your execution, the public's right to access the execution, and so on. So for all those reasons, the protocol is a rule. There is no debate here that it was not issued under the procedures required by the APA and that therefore has to be invalidated. I'd like to now turn to the alternative claim that's at issue in this case. That's the claim under 20-212. Our position is that if the APA does not apply to the protocol, then 20-212 must. And that's because the state has claimed the exemption that applies to the board, but it's beyond dispute that 20-212 imposes certain rulemaking requirements on the board. So if the board's exemption applies, the board's legal duties apply as well.
Is there, aside from that argument, that is pivoting off of the state's position, is there any other argument that your client is advancing that 20-212 imposes any type of rulemaking requirements on the director?
Your Honor, the only thing I would note in that regard is that there is language in 20-212 that suggests that it might, in fact, not just apply to the board. It does refer in a couple of places to the department and to the department's rules in particular. So it could be argued that even the department and the director as the chief of the department could have responsibilities under 212, which I would also offer as an alternative theory to our primary argument, which is that the APA applies. The procedural posture of the 20-212 claim is that it was never in the complaint because, as Justice Brody observed, it was raised in response to the state's motion to dismiss. So the standard here is a low one. It's just whether it's conceivable that Mr. Pizzuto might be entitled to relief on the claim, and that low hurdle is easily cleared here. There are 2 issues with respect to 212 that I wanted to address. The first is the scope of the statute itself. The statute deals with rulemaking to carry out the provisions of, quote, this chapter, and that's the language that the district court seized upon to reason that the execution protocol falls outside the statute because in the district court's view, executions are a category that is not under this chapter, that is chapter 2 of Title 20, because it instead falls under 2716. But respectfully, that's not correct because chapter 2 is quite a broad grant of authority to the Board of Corrections. And it, in fact, deals with all of the board's powers. And in particular, it includes a grant of authority with respect to, quote, the control, direction, and management of all prisons. And executions take place in Idaho's prisons. They're carried out by Idaho prison officials, and they do fall within that broad grant of authority. And I would note as well that the board agrees with our reading, presumably, because the board itself issues its own execution rule pursuant to 212. The other issue with respect to 212 that I wanted to touch upon is the internal management exception to the statute. This is a theory that the state has argued, not one that was adopted by the district court. For that exception to apply, the agency statement has to concern only internal material and not affect the public in any respect. The protocol is not internal. It, in fact, impacts a number of people outside IDOC's orbit, including media, witnesses to the execution, visitors to the inmate, chaplains, contractors, employees of the coroner's office, demonstrators, law enforcement, and the inmates' counsel. And the protocol also does affect the public's rights. The public, as I said earlier, has a right to some degree of access to executions. That's been recognized by the Ninth Circuit in multiple published opinions that do constitute the law in Idaho. And the state's argument below that because that right to access isn't absolute, that it's somehow meaningless, is not persuasive, because no right is absolute. And that's particularly true in the correctional context, where, as the state rightly observes, all rights are balanced against the state's interest in security and so forth. I'll finally say a few words about jurisdiction and the related question of abstention that's been raised in this case.
Excuse me, for some reason, again, cannot hear Mr. Horowitz.
Here's IT has left us. Madam Clerk has stopped.
Nor just Chief Justice Bevan.
Let me see what happened to Brandy, and we'll pause the recording right now too.
Thank you.
Recording stopped.
Let's proceed then with the hope
Recording
that,
in progress.
obviously, if Justice Burdick doesn't hear you, I'm sure he'll let us know.
Thank you, Your Honor. I was just going to briefly address the jurisdictional questions that have been raised in this case. The first have to do with the stay statutes, the statutes prohibiting stays of execution under certain circumstances. The state's view is that those statutes essentially make Mr. Pizzuto's claim unredressable, but that's not the case, mainly because Mr. Pizzuto's prayer for relief included as his first request a declaration declaring the protocol void under the APA. And a declaratory judgment is the form of action that's specifically authorized by the APA, and that type of relief is certainly available to this court and to the district court. As for what I would call the case or controversy requirement, or the requirement that there be an injury, the APA requires only that the plaintiff allege that the agency action threatened to impair his rights. Mr. Pizzuto has done so. The protocol that will be used at his execution certainly affects his rights in quite a meaningful way. The political question doctrine that was invoked by the district court is inapposite here because it's actually quite a straightforward case of statutory interpretation, whether the APA applies. And the district court reasoned that because the question here is how much input the public will have into executions, that's something best reserved to the legislature. But that's always the question under the APA. The question is always whether the public has a right to participate in the process. So that logic would render the APA meaningless, despite the fact that the APA includes a cause of action for plaintiffs. And finally, in terms of abstention, the district court stated that there were other avenues that Mr. Pizzuto should have pursued for his claim instead of this declaratory judgment action under the APA. There are no other avenues that would have been available to Mr. Pizzuto. His claim is that the public had a right to notice and comment, and that the APA should have been followed. The APA is the source of that claim. There is nothing else that would have vindicated Mr. Pizzuto's theory. The district court mentioned the criminal litigation, the direct appeal, state post-conviction, federal habeas, but those are all forms that exist only to litigate the legality of a conviction and a sentence. They do not afford an inmate or a defendant a chance to litigate the APA or the public participation claim, which is at the heart of this case. If there are no further questions, I'll reserve the remainder of my time for rebuttal.
Counsel, I have a question. Given that this was a capital case, I had promised myself I wouldn't ask it unless you ended early, but you ended early. You've begun your brief, I think, by stating your obvious interest in this case. Your client is challenging the procedures by which he would be executed, and he's alleging that those procedures were adopted unlawfully. I understand the importance of both of those points. But typically when we receive challenges to agency regulations and things that are similar to this, there's something more. There's something about the regulations that they don't like. And for standing and just demonstrating an injury in fact, usually when we hear these kind of cases, someone points to something in the rules to say, well, these rules that were adopted have this in them, and I don't think that's right. In this case, that's kind of what's missing. I wanted to give you an opportunity to help me understand why this is more than just not an act. I realize your client's life and the manner with which it could be taken is at stake, and I don't want to minimize that. But what can you tell me to satisfy me that this is more than just academic?
Yes, Your Honor. That's a good question and a difficult one to answer. I think I would have to acknowledge the fact that there are challenges to Mr. Pizzuto's execution that are pending and going forward in federal court, and that in our view, that is the forum, or that is in fact the forum where the substantive challenges to the state's plans for carrying out this execution have been alleged and are being litigated. And those include Eighth Amendment questions that have been raised about the substantive content of the protocol and the state's plans for carrying out the execution, and whether they raise the possibility of a cruel and unusual death in violation of the Eighth Amendment. So I would say those issues certainly exist. It's just that this case is limited to the procedural violation, which is not to say that there aren't, that I would concede that the protocol is acceptable constitutionally in a more substantive way. We absolutely have those challenges. It's just that they've been asserted in another forum.
So this is a mechanism to buy additional time?
No, Your Honor, this is a mechanism to require the state to go through the process that it was required to go through in issuing the protocol, which is to follow the APA and to allow the public some input into an extremely important life and death type of process that it has instead shrouded in secrecy, which is ultimately the interest that is protected by the APA, even though, as you say, there are oftentimes other arguments people assert in APA cases that they're not required to, and sometimes they don't. And in any event, when a state agency is required to follow the APA and fails to follow the APA, that does constitute a violation that must be redressed.
Sir, as concerns your statement that this was done in secrecy, that this procedure is in fact published, is it not? It is in fact being challenged in the federal courts, and therefore, why is there even the word secrecy?
Yes, Your Honor. I would say it's secret in the sense that nothing that went into it has been made public, and maybe secret's not the best word. Maybe non-transparent or something along those lines is a better way of characterizing it. But unlike a rule that's promulgated under the APA, there was no window for the public to see why IDOC or why the director chose to craft the protocol the way that he did. There was no opportunity for any relevant experts to contribute, so far as we know, for any relevant experts to contribute their wisdom and insight. And so in that way, it's not transparent. There's not.
It's the fact that the case in controversy issue is now before the federal court rendered this moot.
No, Your Honor, because the APA issue is not before the federal court. There's no question in front of the federal court as to the process by which the protocol was adopted. There are some cases in federal court having to do with direct constitutional challenges to the protocol, but those don't encompass the claim that Mr. Pizzuto is presenting here.
Thank you.
Thank you, Your Honor.
Thank you very much, sir. Appears there are no other questions now then, so we'll turn to Mr. Jorgensen, please.
May it please the court. As counsel has acknowledged, or all but acknowledged, this is a public comment case. The only right at this point being asserted is the generalized public right to comment on the protocols for carrying out of a death warrant. Mr. Pizzuto's counsel has acknowledged, as I think he must, that the actual challenges to the way that his own execution will be carried out will be addressed in different forms. It will be addressed in the federal court. It has been addressed in the state court. The district court made the specific finding that the constitutional, statutory, and other claims have been addressed through different media. So the only question before this court is whether there is a generalized public comment right, and more importantly, whether Mr. Pizzuto can effectively assert that right and thus gain jurisdiction and standing. At this point, it is also uncontested that Idaho Code Section 192708 does bar any sort of injunction of the execution of the warrant. I realize in the briefs there's a constitutional argument made. However, that argument has been made at no point prior to the reply brief, and therefore is not before this court. If it were before this court, it would lack merit. So ultimately, this case just does come down to whether public comment on the protocols was mandated by the legislature. And the state would argue that it does not. And the fact that it is just about that case shows that the district court properly determined that it lacked either jurisdiction or that it properly determined that it should not go forward with a case of this nature where there was no injury, in fact, could be remedied. As to the merits of the case, there's one important point that the defendants wish to make here, and that is the bootstrapping of the APA into statutory interpretation. The state's reading, excuse me, not the state. I usually represent the state. Today, I'm representing other people. But the defendant's view is that that the ADA test is applicable once the rulemaking authority has already been established. In other words, once the legislature grants rulemaking authority to an agency, the ADA test is applicable to determine whether the agency is or is not exercising that particular authority. It doesn't apply to statutory interpretation. In other words, that test is not the one we would apply or that this court would apply to whether Section 1927-16 grants rulemaking authority or not. The first step of the analysis is to look at whether 1927-16 grants rulemaking authority. Only if it does would the APA test as to whether that authority is being exercised be applicable. The plain language of that statute does not grant rulemaking authority to the director. The district court correctly held that this particular legislative delegation of authority was simply to carry out a court's warrant and not to create rules subject to public comment, public input, that sort of thing, as claimed by Mr. Pizzuto. Thus, this claim initially—
Mr. Jorgensen, when you look at the document that was actually promulgated, everything about it looks and smells like administrative rulemaking. I mean, can we really divorce ourselves from the product itself that was put together and well, I should say that was approved by the director here?
I'm not sure if I understand the question, quite frankly, Your Honor, because the first question is whether the statute requires something. If the statute requires rulemaking authority, then it has to comply with the rulemaking authority. If the statute doesn't, whether or not the agency did or did something that looked like it is ultimately irrelevant. In other words, Your Honor, I do occasionally get to deal with bureaucracies, and I'm really not surprised they tend to do things with the way they're familiar and comfortable with doing them, regardless of what the legislature has said. So any mere superficial parallels to what the director did in adopting these protocols to rulemaking is ultimately not controlling. What is ultimately controlling is the language of the statute.
So what does the statute authorize the director to do then? I mean, how does he carry it out?
The director shall determine the procedures to be used in an execution, in any execution. So the director has decided not to do this on necessarily a case-by-case basis. There have been protocols in place since 1998. They were revised in 2012, and then they were revised again in 2021. So not surprisingly, the director has decided to establish protocols that are that will be applicable, however, are not necessarily binding. The director could change those protocols. Certainly, doing so would give Mr. Pizzuto opportunities under habeas, either in state or federal court, to challenge those particular procedures to be used, those particular protocols. But the APA is not one of those venues for challenging that. The language of the statute does not say create rules. It says determine the procedure. I would submit the rest of it on the brief in terms of if this court ultimately does apply the APA, that's set forward. There is a little bit of a bootstrap involved in Mr. Pizzuto's argument here, and that is an agency, given it the definition of 675201 sub 2, it means a state board, commission, department, or officer authorized by law to make rules. So to say that it's an agency because it makes rules, and it makes rules because it's an agency is completely circulatory. And that's why this court has to first look at the statute itself and look at whether the director is somebody specifically authorized to make rules. Now, normally that language of department or officer, the officer would be exercising the agency's authority, not an individually delegated authority. To my knowledge, this is unique in directing to a particular office as opposed to an overall agency in terms of rulemaking authority. So that the director is the subject of this indicates that this is not rulemaking authority. The plain language of determining the procedure to be used indicates this is not rulemaking authority. The legislature has very clearly, multiple times, stated that it is creating rulemaking authority. It did not do so in this case, and therefore the district court did not err either in determining that this was not justiciable as presented or on the merits, and therefore the defendants would request this court affirm.
Do you know if there's a reason for why this is being handled if we interpret 1927-16 the way that you're interpreting it? Do you know if there's a reason why it's being handled so differently?
I'm not sure if I understand what you mean by handled so differently.
Well, if this is unique, are there reasons for making it unique?
Yes, I think there are reasons for making it unique, and that would be primarily to avoid what we have right in front of us. The legislature has spoken very clearly that it doesn't want this kind of interference in relation to these types of cases, and I think with good cause. In other words, there's really no reason to believe that the legislature intended for the citizens of Idaho to have a general right to have input on what protocols are going to be used. And they certainly said that the defendants in capital cases don't have the right to intervene on this basis. So looking at all this together, then yes, I think that the legislature is very clear in saying that the director does have to have protocols. Those protocols are subject to challenge, but they're subject to challenge within certain venues and by certain procedural mechanisms, exclusive of mechanisms such as the APA and exclusive such as the declaratory judgment statute. They are to be in the criminal case, in the unified post-conviction case, in a subsequent post-conviction case, in a habeas case. There are multiple mechanisms by which this procedure and the other aspects of the conviction and sentence can be challenged. And the legislature has spoken quite clearly that this is too peripheral and it is not one of the venues to be pursued. And the district court said as much, and the district court did not err in doing so.
I would agree that there's some aspects of this that I'm not sure the public necessarily needs to be providing that kind of specific input on, but public is a very broad term, and some of the things that this procedure does affects those. For example, the media and who and how many and how they're going to be able to exercise their First Amendment right, the families of the victim, the families of the defendant, the sheriff of the county that's involved. All of those are touched on in this very comprehensive procedural outline, and yet they didn't have any involvement at all in the construction of this that at least transparently we can tell. Should that be a concern for us?
No, it shouldn't, because frankly, if this particular protocol, even if you strike it down, there's one in place since 2012 that isn't subject to any of this. So the idea that when the director develops this protocol, at that point, the public has input, and then at no other point doesn't really serve what you're talking about anyway. In other words, this seems to be that, if you're a newspaper and you are concerned about your view of the execution, you had to bring suit in 2012 in order to have standing today to challenge the 2012 one. That doesn't really address that concern at all. So I don't believe that the defendants have to give an explanation of that. I don't think the district court did either. The only question is whether Mr. Pizzuto can pursue this in the fashion that he did. The district court said no, effectively, he doesn't have the standing that's required to go forward, especially given that he can't actually stay his execution. And that determination, if affirmed on that limited basis, is required under the facts of this case. Whether the sheriff wants to challenge this, whether the press wants to challenge this, those sorts of things, because these protocols arguably affect them. Well, those are claims for them to raise, not Mr. Pizzuto. And that's exactly what the district court said, that the standing issue isn't here because Mr. Pizzuto has many options and many avenues to pursue his interests, and this simply isn't one of them.
There are no further questions from the court. Thank you, Mr. Jorgensen. Madam Clerk, how much time remains for Mr. Horwitz?
8 minutes, Your Honor.
Sure.
Thank you, Your Honor. I did want to go back to Justice Muller's question just briefly about whether there needs to be some kind of substantive, or the question of whether there's sort of a substantive challenge to the protocol. Just to mention that I think the environmental cases that deal with procedural rights are helpful with respect to that question, because in many of those cases, I believe the organization or the company that's challenging the environmental regulation is also not necessarily saying anything about the substance, not necessarily saying there's anything unlawful about the substance. They are just challenging the procedure by which that regulation was passed. I think that's true of the Asarco case, as I recall. As for the rulemaking authority of the director, I would strongly disagree with opposing counsel's assertion that we're taking a circular approach. We are looking at the same statute that the defendants are looking at, which is 2716, and whether it confers rulemaking authority, and we believe it does. That's just a disagreement about the meaning of that statute. In terms of the meaning of that statute, the state has insisted that this court should not look at the definition in the APA of what a rule is while determining whether an agency statement is a rule for purposes of the APA, I have not seen any authority for that counterintuitive suggestion by the state. And we have presented authority for our contrary view, which is an opinion from the Illinois Supreme Court that confirms the common sense notion that a statutory definition of the term rule is in fact relevant for determining whether an agency statement is a rule. And that's not a matter of using canons of legislative interpretation any more than using any statutory definition and determining whether it is satisfied or not. I wanted to respond to opposing counsel's comments about the legislative intent. Opposing counsel asserted that there's no reason to believe that there was a legislative intent to bring the protocol within the coverage of the APA. But what the defendants have never pointed to is any reason then why the legislature would use the language that it did in 2716, which is to determine the procedures for executions. That is not language that appeared in prior versions of the statute, and the language that had been used previously was certainly available to the legislature. It could have said exactly what it had said historically, which is the director or whoever the relevant was has to make sure these executions happen. But that's not what the legislature did in 2716. I'd like to also go back to our redressability because that has been a focus of the state, both in its briefing and at oral argument. There really is, there's no difference between Mr. Pizzuto's position with respect to the main remedy that he's seeking, which is that the protocol be declared void, and the remedy that any other APA plaintiff would seek. The state statutes don't foreclose that declaration. And so I would view it really as a red herring in this case. And the state's position essentially, I think, can be summed up as because the relief Mr. Pizzuto gets might not prevent him from being executed, therefore he has no standing. But that's never been this court or any court's approach to APA claims or to declaratory judgment actions, because in every APA proceeding, there is a possibility that the agency will reissue the exact same statement, but this time make it available for notice and comment. And that person could be out of luck then. They could be in the same boat that they're in to begin with. And that doesn't deprive courts of jurisdiction to rule on those APA claims. The state also indicated that, and this is something that appeared in the state's briefing below as well, which is that Mr. Pizzuto may lack standing to assert the rights of the public. But again, that's not really how APA claims work or how standing works. Whatever the party is in an APA case, their main argument is by definition that the statement at issue should have been made available for public and comment by everyone, as you said, Justice Mueller, by every member of the public, no matter what their role is or what their interest in the statement. So in that sense, any APA plaintiff is relying on the public's interest, but that person has standing if, as the federal courts have said, if their rights are meant to be protected by the agency statement at issue. And that is undeniably the case with Mr. Pizzuto, who obviously is facing execution under this protocol. And the protocol explicitly refers to the defendant's interest in not subjecting a condemned inmate to unconstitutional or to cruel pain and suffering. So that's an explicit recognition that the protocol was created in part to protect the interests of people like Mr. Pizzuto, and that is sufficient to confer standing on him. And just a brief word about preservation, something the state has argued in its briefs and again referenced at oral argument. This idea that Mr. Pizzuto forfeited some theory that he needed to assert in his opening brief, that is not accurate. The language the state is really concentrating on.
Again, I am sorry to interrupt. I cannot hear Mr. Horowitz.
Can you hear me, Justice? Can you hear me?
Brandy, can you take a look at Justice Burdick's computer, please?
Yeah, I'm jumping on there. Are you able to hear us now?
Yes, thank you.
Thank you
Recording
once
in
again, Mr.
progress.
Horowitz. Please proceed.
Thank you, Your Honor. As to preservation, the state is really concentrating on two sentences in the district court's quite lengthy order, to the exclusion of almost everything else in the order. Two sentences where the district court makes passing reference to the stay statutes. Mr. Pizzuto did deal with those sentences in his opening brief. The sentences appear in a section about justiciability and about the political question doctrine and about whether Mr. Pizzuto has a particularly adverse interest in this lawsuit that's not shared by every other member of the public. Mr. Pizzuto addressed all of those issues in his opening brief. The state, as its prerogative, chooses to read the district court's analysis differently, but that doesn't constitute any sort of waiver on Mr. Pizzuto's part. He did address the district court's reasoning as he read it, and he has now addressed the state's construction of that same reasoning as creating some sort of jurisdictional problem having to do with a request for a stay, which again is not what the district court suggested. But in any event, we have fully engaged with that theory, and there's no reason why this court shouldn't resolve that disagreement and answer the important question in this case. If there are no further questions, I thank the court for its time.
Appears there are none. So thank you, Mr. Horowitz. Thank you to both
Thank you, Your
counsel
Honor.
for your time and effort in this matter today. The case is now under consideration. We will render an opinion, and we will be in recess until Wednesday at 8:50 a.m. Thank you all.